Okay, good afternoon, everyone, and welcome to today's webinar. My name is Nicholas Robertson, and I am a solicitor here at JB Solicitors. Today's webinar topic is on sperm donors and whether or not you can be considered the child's parent. In this webinar, I'll be going through mainly the interpretation of Section 60H of the Family Law Act and its application in the most recent case of Mason and Parsons, which was a High Court decision handed down earlier this year. So before we start, I'll just cover a few housekeeping rules. On your screen, apologies. So on your screen, you should see a dialog box, and on this dialog box, there is an orange arrow you can click on to minimize or maximize the dialog box. The only person here today whose microphone will be on and heard during the webinar is myself. So for the purposes of this webinar, everyone else's microphone has been muted and I'm not able to hear any of you. If you do have any questions, however, there is a questions box that you can type your answer in. I will try my best to answer your questions during the webinar. However, if I don't get around to it, I will ensure that I will get around to getting in contact with you after so that I can answer any questions that you've had. On the left, there's also a raise hand button. Can I please get a show of hands who is here and able to hear me? Okay, thank you. Now, before we start, I'll quickly go through our disclaimer. So this webinar is just general advice, and obviously every single case, person, and scenario is different. Of course, we would like to provide everyone with tailored advice, and we are able to do that if you would like to get in contact with us via email, contacting our number through our website, or if you just like to call our office. By doing this, we can give you specific advice to your actual circumstances. Today's webinar is just a simple way to provide general advice and make sure that everyone is aware of the recent development in family law, particularly in the case of parentage and sperm donors. So let's begin. Today's webinar, I'll be going through a bit of a case summary and analysis. I'm going to be discussing the recent High Court decision of Mason and Parsons. This landmark High Court decision was delivered on the 19th of June 2019 and has provided valuable insight into the meaning of what a parent is in circumstances surrounding children born through artificial conception procedures. So to give a bit of a factual background to the case, the appellant, who is called Robert, and the first respondent, who was called Susan, were friends for many years. Robert and Susan came to an agreement that Robert would help Susan conceive a child and donate his sperm for the purposes of this conception. There were two attempts that were made in October and November of 2006. The second respondent, who is called Margaret, entered into a relationship with Susan in May of 2006, although she conceded that she became committed to the relationship in August of 2006. So you'll see that there'll be issues with regards to the de facto status of Susan and Margaret. So Robert remained a close part of the child's life when the child was born, introduced her to his extended family and played a daily role in her day-to-day life. He was also listed as the parent on the child's birth certificate and was also referred to as Daddy by the child. Robert then discovered that the respondents were considering relocating to New Zealand. He then decided to initiate proceedings in the family court to prevent the respondents from this relocation. Whilst Robert relied on the Family Law Act to assert his right as a parent, the respondents, and this is where we get into a few constitutional issues with the decision, the respondents attempted to use the provisions of the New South Wales Status of Children Act like I said, it's a state legislation to support their assertion that Robert should not be considered a parent. For the purposes of this webinar, however, although I've referred to state legislation, I will only be attempting to discuss the provisions contained in the Family Law Act. And given that we're dealing with sperm donors and artificial conception procedures, I'll look at the interpretation of Section 60H. So Section 60H deals with the parentage of children born as a result of artificial conception procedures. And I've given you subsection 1 of Section 60H in the slides. I do note that there are 6 subsections. However, for the purposes of this webinar, I just want to go through the subsection 1. So subsection 1 states that if a child is born to a woman as a result of the carrying out of an artificial conception procedure while the woman was married to or a de facto partner of another person, and this is where it gets interesting, the other intended parents, and either the woman and the other intended parent consented to the carrying out of the procedure, and any other person who provided the genetic material used in the procedure consented to this, or under a prescribed law of the Commonwealth or of a state or territory, the child is a child of the woman and of the other intended parent. Then whether or not the child is biologically a child of the woman and of the other intended parent, then the child is considered, the child is the child of the woman and of the other intended parent. And Part D, you can see that if a person other than the woman and the other intended parent provided genetic material, the child is not the child of that person. So in this case, we have Robert, who's provided his sperm and had an intention of being an active part in the child's life. However, when we look at this, at the interpretation of Section 60H, you'll see that in a sense, by providing that genetic material, if there is a other intended parent, then the definition of parent for the purposes of this section is only meant to be for the other intended parent, and unfortunately doesn't apply to Robert. So it's a bit of an issue to determine, firstly, at the first instance, 1, what the status of Susan and Margaret were as a de facto couple, and 2, whether or not in the circumstances Robert could be considered a parent. So let's look at the first instance decision. And on first instance, you'll see that the court actually held that Robert was a parent under the provisions of the Family Law Act. In paragraph 24 of the High Court judgment, the court held that the court relied on the decision of Cronin J in the case of Groth and Banks, a 2013 decision. And I've just quoted what they said here. Because the appellant is the biological father of the child and unaware of any de facto relationship between the first and second respondents. So obviously in the first decision, it was held that Susan and Margaret were not in a de facto relationship at the time of when Robert and Susan came to the agreement to donate his sperm so she could conceive a child. Robert provided his genetic material for the express purposes of fathering a child whom he expected to help parent by financial support and physical care, which he had since done. The appellant is a parent of the child within the ordinary meaning of the word parent, and therefore a parent of the child for the purposes of the Family Law Act. So it was acknowledged that whilst Robert might not have fallen into the category of a parent under Section 60H, there were, when looking at the circumstances of the case, other factors that needed to be taken into account that substantiated his claim that he should be considered a parent of the child. This was then appealed by the first and second respondents to the full court of the family court. And on appeal, the original decision of the first instance judge was actually overturned and held that Robert was not a parent under the provisions of the Family Law Act. In coming to this decision, that then allowed the respondents to actually move to New Zealand with the child because Robert was not a parent anymore. And I'll just quickly read out paragraph 26 of the High Court decision, just the last couple of lines where the now retired Judge Thackeray came to the conclusion in relation to section 60H1 paragraph D. And it states that where a child is born to a woman as a result of an artificial conception procedure, while the woman is married to or a de facto partner of an other intended parent, a person other than the woman and intended partner who provides genetic or material for the purposes of the procedure is not the parent of the child. So overall, that just stated that Robert, in the circumstances, was not considered a parent of the child. There were also other issues to take into account. As mentioned previously, the respondents tried to rely on statutory provisions of the New South Wales Status of Children's Act, and Thackeray made some comments in relation to whether or not the Family Law Act was up to date with the provisions of the state and territory legislation. So you could see originally that there's quite a conflict in relation to whether or not the family law provision should have been referred to, or whether or not the respondents were even allowed in the first place to rely on the New South Wales provisions. So moving on, obviously Robert then appealed this decision to the High Court, and the High Court ultimately overturned the decision of the appeal judge, which held that Robert was in fact a parent under the provisions of the Family Law Act. And when it came to this decision, it all came down to how the definition of the word parent should be construed. And the High Court actually held that the meaning of the word parent under section 60H and in extension section 60G, but I haven't talked about that in this webinar, but the meaning of the word parent is not exhaustive, and the interpretation of such is entirely dependent on the circumstances of the case. So obviously in this case, as Robert had quite a significant involvement in the child's life, he was on the child's birth certificate, he provided financial support throughout the whole child's upbringing, was referred to as daddy by the child, and was had quite a significant relationship in the child's life. The court then accepted that, and in quotations, in the circumstances of this case, no reason has been shown to doubt the primary judge's conclusion that the appellant is a parent of his daughter. When we're looking at Robert's status as a sperm donor, the court was quick to state that to characterize the appellant as a sperm donor is in effect to ignore all but one of the facts and circumstances which, in this case, have been held to be determinative. So there was no opposition that Robert was a sperm donor. However, it's interesting to understand the court's interpretation that a sperm donor for the purposes of section 60H is only one of many factors to take into account when looking at whether or not a sperm donor should be considered a parent of the child. So it goes to, I guess, the cliche saying in law that everything depends on the facts and circumstances of the case. As the court notes and the High Court notes as well, the fact that a person is a sperm donor is only one consideration when determining parentage. The Family Law Act doesn't actually have a set meaning of the word parent, so the High Court allowed for the definition of the word parent to remain quite open to interpretation, giving it a quite broad meaning, so that way it doesn't refine or restrict people such as Robert, who are sperm donors and have maintained a significant role in the child's life, to bar them from a claim to parentage and from relying on the provisions of the Family Law Act. And just very quickly, as a sort of constitutional issue, I mentioned before that the respondents attempted to rely on the provisions of the New South Wales legislation. Again, when we looked at the Constitution, Section 109, obviously where there's an inconsistency between the federal and state law, the federal law must prevail. So you'll see that the proper law, or the proper jurisdiction that was to be referred to when determining parentage is the provisions of the Family Law Act, as it is a Commonwealth legislation. So what's the significance, I guess, of this case? And I'll go through a few things. So obviously, as I've said before, the meaning of the word parent is not exhaustive, and everything is entirely dependent on the circumstances of the case. The High Court noted that Robert's status as a sperm donor, I've mentioned this before, is only one factor. And you'll see up here on the screen that I guess the High Court has opened discussions for family lawyers and made a contemporary shift of the meaning of a parent under the family law provisions. This means that sperm donors, whilst I guess under Section 60H might not be considered a parent, given the phrase of within the section being referring to the other intended parent, this does not bar sperm donors from, I guess, making a claim of parentage. You'll see that the law has adapted to allow sperm donors greater rights in being able to claim a parental entitlement to a child, and this has significant impacts on the courts assessing the paramount consideration of the best interests of the child. Obviously, I've only referred to Section 60H in looking at what the rights of sperm donors are, but obviously this needs to also be read in light of all the sections of Part 7 of the Family Law Act, which obviously deals with all rights and obligations in relation to parental responsibility. So obviously Section 60H is just one sort of section to be taken into account when we're looking at artificial conception procedures and what rights sperm donors do have should they wish to approach the family law courts to be classified as a parent of a child. So I guess that concludes today's webinar. If there's any other questions which you may like to ask or perhaps follow up on following this webinar, feel free to give us a call on 1300 287 911. You can also give us a call, I guess, on 9723 8080. We have, I guess that concludes today's webinar. Thank you all for listening in. I'm open to any last minute questions, should you have any. No? Okay, well, thank you everyone for participating, and we look forward to your participation in our webinars in future events. Thank you very much.